Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today I want to speak about an E-2 visa refusal based on a 221G refusal, for which the case was placed in administrative processing at the US Consulate in Toronto. I know we typically speak about E-2 visa success stories, but on very rare occasions we have refusals, and it is important to speak about these refusals as well. Now, in this specific case, this refusal is about collecting additional documents, so it is not a hard refusal. It is effectively a temporary refusal until the US Consulate collects additional documents. However, the case is very interesting because this situation can be encountered by many of you, especially those of you who in the past had DUIs in the United States, because effectively this 221G for the E-2 visa case was issued for DUI. So for documents related to a DUI from many years ago. But before we go further into the details, I want to ask you to subscribe to our channel or click the bell button in order to receive notifications. We are not going to discuss the details of the E-2 visa case because the US Consulate did not take issue with the E-2 visa case per se, but instead the US Consulate issued the 221G refusal for a DUI charge that the spouse of the investor had almost 20 years ago. So in this case, the investor, a Canadian citizen, was in fact applying to renew his E-2 visa at the US Consulate in Toronto, which issued their initial E-2 visa, when during the interview the US consular officer took issue with his wife's DUI charge from over 20 years ago and issued a 221G refusal pending a final decision after the wife will be able to provide additional documents to the US Consulate to make a final decision. Now, you need to understand that the wife of the investor actually followed everything that was necessary for the DUI charge, and also, which happened over 20 years ago, and also took all the necessary steps through attorneys to expunge the record. However, the US Consulate asked to be provided with criminal record check in Canada, so a recent criminal record check in Canada, and also all the dispositions, so all the court records from the state and the county regarding the DUI charges, and the documents to contain also the alcohol level in the blood at the time of the DUI. So effectively what has happened here is that the E-2 visa renewal case was temporarily denied, refused under 221G and placed in administrative processing because of the investor's wife's DUI charge from 20 years ago. There are two important lessons to keep in mind and to take from this specific case. That if you have a DUI charge, no matter how old, be it 10 years ago, 20 years ago, for the purpose of US immigration and seeking immigration benefits, either green cards or visas or citizenship, the DUI charge must be disclosed no matter how old, and you must also have documents with you related to that charge. And the second lesson is that even if you expunge that record, it does not matter for the purposes of US immigration. So while expunging the record may matter in your daily life, such as when you seek employment and your employer is doing a background check on you, then the charge is not going to appear. But for the purposes of immigration law and US immigration law, even if you have expunged that charge, that does not mean that it cannot be seen by immigration. In fact, you still need to provide documentation related to the DUI, even you have expunged that record. Now, the reason why these documents are important and why this is an important lesson is to basically inform you, and especially those of you who have a DUI charge, that no matter how old your charge is, and even if you've expunged that record, when it comes to applying for US immigration benefits, you should bring all your documents with you related to the charge. Otherwise, what will happen, like in this case, the US consular officer will refuse your application, your visa, place the case in administrative processing, and ask for additional documents. In this case, the consular officer asked for criminal record check in Canada and also all the dispositions of the US DUI case, including the alcohol level in the blood. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.